Hi, I'm Liza. I'm the Criminal Expungement Program Manager for Volunteer Lawyers Network. And today I'm going to be presenting on our full representation criminal expungement training. Just going to take a moment to share my screen with you. Okay, so today we'll be going over the need for expungements, working with VLN clients, the law, how you take a case through Volunteer Lawyers Network, and resources and contacts. This is a chart of all of the arrests in Minnesota by year, going back to 1996, just to show you the scope of the potential problem of criminal records, because none of these records go away without expunging them. And obviously not all of these arrests led to conviction, but you can see, in 1998, it looks like there were over 250,000 arrests per year. It's gotten down to about 150,000. But it is an extensive problem and, one that you're helping to alleviate. So these records are public online, most of them are, and there's a trend towards more information, including complaints, documents, things like that. So as these become more transparent, which is good in some sense, it's also easier to find someone's criminal record and it can hurt them more. Additionally, these records do not go away unless you go through the criminal expungement process. So criminal expungement is important not only because of the issue I just discussed, the fact that these records don't go away unless you expunge them, but it's really only a problem because we make it a problem as our society. We exclude people with criminal histories from employment, housing, and increasingly other areas of life. So, even an arrest record can impact your employment, housing. Landlords can be very picky because they have so much demand. So any record can, knock you out of that pool. We are increasingly seeing people being denied volunteering opportunities, coaching, community service, and things like that because of background checks done. Another really important reason is because we have, systemic racism in our criminal justice system. This topic is really important and one of the main reasons why expungement is so important. And it really deserves its own separate discussion. So we do have resources on our website about the collateral consequences and systemic racism in the criminal justice system and how that impacts criminal expungement, which touches on the subject in the way that it deserves. It also keeps people in poverty because they can't, get jobs, can't support themselves, and end up having to rely on benefits, friends, things like that. So VLN serves people whose income is 300% of the federal poverty guidelines and below. The criminal expungement program, in particular, serves people in that same category, but we have a couple different services we provide people based on their income. All of our clients start with a screening call where I screen their criminal records and discuss criminal expungement with them. If they're ready to go through criminal expungement, we then have a couple services. The first is brief workshops. These are going to be for clients who have a very simple case, a single case, or a petty misdemeanor, a very old case, things like that. And brief services really, or the other category is for people whose income is 200% of the federal poverty guidelines to 300%. So that's going to be between 26,000 and 38,000 about per year. These people receive an attorney filling out their criminal expungement petition, filing it, and serving it for them, but they will represent themselves in court. Criminal expungement is a process that's meant to be for pro se parties. As you will see, it can be a little bit confusing, and especially the administrative side, it can be very burdensome for clients, especially those who don't have, funds. So that's why we make sure that our full representation cases are 200% of the federal poverty guidelines and below, because we want to make sure those people are, the people receiving our full representation really need that attorney, that free attorney. And then as staff, the staff is myself and then Barb, probably who you've already been in contact with, but we are here to help you throughout the case. I will do one-on-one support with you on the law, the process, any other questions you have. And then we also provide support to clients. So, we walk them through the process, answer questions that they may have, and are generally just here to make the process easy for you. So when you're working with a VLN client, I just always like to remind people, which I know you know, but you have the same duties towards your pro bono clients as you do towards your other clients, to be timely and responsive to them. Many of them are in difficult situations and are really looking forward to this process to alleviate some of those difficulties. And then just some general, reminders and ways to make sure you're thinking a little bit differently about your pro bono clients who may have some different challenges as your regular clients. Obviously, just in everyday life, as in here, making sure to use clients' proper pronouns, pronouncing clients' names right, and we do have some transgender clients. Trauma triggers are something to think about, especially if your client isn't reacting in a way that you would expect, either kind of shutting down or a bigger reaction than you would expect. They may have some ongoing trauma or past trauma that talking about this criminal history brings up, or stress reactions, things like that. If you ever need help communicating with or feeling like you are having issues communicating with your client, please let Barb and I know. We have a lot of experience with, figuring out how to make sure you and your client are communicating well in a way that works for both of you. Some of our clients have ongoing poverty or crises. That means that they may not be as responsive, or they may be very responsive and then stop and then come back. Most of our clients complete the full process, but sometimes they have more pressing needs that come up, and they don't communicate that to you. Other clients are very vocal or want to discuss the fact that they feel like, they've experienced racism in the system. They were targeted because of their race. And that can be true, right? One of the things we talked about was criminal expungement. It's important because of that systemic racism in our criminal justice system. So absolutely acknowledging your clients' thoughts on this issue and feelings on that is important. Some barriers that our clients face include communication issues as far as not having reliable telephones or cell phones. It's always good to get multiple methods of contacting your client in case their cell phone doesn't work, like a second person to call in case you can't reach them. Especially with Zoom now being a very important part of all of our lives, making sure your client has the technology to successfully, attend the Zoom hearing or, reach you, things like that. Discussing what their technology problems are. They may not be very good at technology. Other clients are extremely comfortable with it. So just feeling that out is important. Transportation is less important now than it was when we had in-person hearings, but if you're going to be meeting in person at all, talking about transportation or childcare, both are important. So there are a couple different types of expungement. The main expungement statute is 609A. This is what we refer to as statutory expungement. Then there's also inherent authority expungement. This is where the court uses their own powers to expunge records. So there are a couple other little statutes that we'll discuss, but all of the basics are the same. So expungement is the stealing of criminal records, not the destruction. These records can be reopened, but really I've never seen that happen. Criminal record agencies can view them. Criminal justice agencies can view them, but in very limited circumstances. So just when investigating a crime or prosecuting a crime, and also for if someone applies to their agency. So the overall process is pretty long. It can take up to a year based on how fast you and your client work together. Once you prepare your case, you're going to serve it and file it. Service is basically just mailing your petition, the expungement petitions, to the parties who are involved in the original criminal case to let them know that you're filing, you are filing into that case again. So you're going to serve and file it, and then there's a 2-month delay in between the service and the hearing date. It's 2 months minimum. You'll have a short court hearing, and then the courts have 3 months to issue an order, although usually it takes a much shorter period of time. If the case is approved, then it's going to be 2 months between the date the case is approved and the time when the court expunges the records. The court will do it themselves, and they will notify all of the other agencies that need to expunge the records that they need to, they'll send out that notice basically. So now I'm going to run through the different types of expungement. So there's arrest only records letters, which is basically where there was no court case created, just arrests only. You just send out a letter. So it's very simple. Then there's statutory expungement, which is under 609A. There's a couple other little statutes in there, but the process is the same. The papers are the same. And we have a program that will pick out the expungement statute for you. This is the same process as inherent authority also. So, and again, we have that program called Hot Docs that will pick out the statute for you. And then I will also tell you what statute and what type of expungement the case qualifies for. So this is really just an overview so you understand it, but you don't have to do this assessment yourself. So statutory expungement is the best. And only cases under 609A and juvenile cases, they qualify for basically full expungement. So what that means is no records show up on background checks, and it seals the court and executive agency records. So this is really the best type of expungement, and it's the most helpful because when people are applying for jobs and housing, it doesn't show up. There are 2 processes to do statutory expungement. The first is the court process, which is the typical one. The second is something called a prosecutor-led expungement. This is only for cases that qualify under 609A, statute 609A. And I will go over that also. Inherent authority is where a judge uses the power over the court system to seal court records. This is not as useful for clients. So you only use this for cases that don't qualify for that statutory or full expungement. The record is still going to be on the client's background check. So, it can still be helpful for clients because it comes off the court records. That means if someone looks up their name, it won't be online. It will, come up on their background check when they're applying for jobs or housing, but the client will also have an expungement order from a judge saying, here's all these good things about the client. This is why they deserve to have an expungement. And that can be influential for some people, for others, it's not. So the crimes that you're going to have a inherent authority expungement for are going to be just serious drug theft or violent felonies. You cannot expunge crimes you have to register for at all. So here's a visual explanation of why statutory expungement is so much better than inherent authority expungement. As you can see with statutory, it covers the courts and then all of these executive branch agencies, like the Department of Human Services. What we can't control is private websites. Inherent authority expungement only covers the court systems. So now we're going to get into the different statutes. So this will be for statutory expungement. Juvenile offenses, it's under statute 260B 198. This is the court process only. If any juvenile offense qualifies for expungement once the case is closed, if the case was certified and tried in adult court, then it's statutory expungement under 609A. With both cases, there's no waiting period, and you use the same form, even though they're different statutes. With cases that ended in dismissal or acquittals, there's two different statutes under 609A. The first is going to be subdivision 3.1, resolved in favor cases. These are going to be cases where there was no guilty plea or facts admitted to. There's no waiting period. So once the case is dismissed, then the client can expunge it. The second type is subdivision 3.2. So this is where the client has pled guilty, but the case was ultimately dismissed. So it will be one where there's a guilty plea, admission of facts, and usually what you'll see is there's going to be a diversion program or stay of adjudication that the client agreed to do. So look out for those two things and that guilty plea. There is a 1-year crime-free waiting period after the case is dismissed with no charges, and then the client can expunge this case. There's also under 609A, something called certain controlled substances offenses ending in dismissal. This is basically a statutorily required stay of adjudication. And if it is dismissed, then there's going to be no waiting period. So the client can just expunge it once the case is dismissed. This is usually going to be for drug felonies. First-time drug felonies, I should say. All right, now let's get to convictions. So petty misdemeanors are, you can expunge them 2 years after they've been discharged. So that means after they've been paid off. Misdemeanors are expungible 2 years once the client has had 2 years after the client has had no new criminal convictions. So that means they've been off probation and have had no convictions for a 2-year period, and then they can apply for expungement. For gross misdemeanors, it's a 4-year conviction-free wait period. And then for felonies, it's a 5-year conviction-free wait period. Additionally, the only felonies that qualify for statutory expungement, and this is all under 609A, I should mention, is going to be there's a list of 50 nonviolent felony convictions. So 5th-degree drug crimes, some theft cases divided by how much was taken, and then a lot of things that nobody's ever heard of, like cattle rustling, things you just see very infrequently, like felons voting. So it's really not a very helpful list, to be honest. And just a tip that a lot of clients have stays of imposition. You can have a stay of imposition is where the client is convicted, but there's no sentence imposed. And then the court will say, if you follow these probationary conditions, will drop down your conviction level. So usually this is a problem when we see a felony case with the stay of imposition, the client fulfills their probationary conditions, and then the case is dropped down to a misdemeanor. For the purposes of expungement, you have to use the original conviction level. So this means a lot of people will say, well, this is a misdemeanor, so it should qualify for expungement. And it's like, no, this is a felony, and it's not on that list of 50 felonies that qualifies for full expungement. So this is a big problem we run into, and just something to, keep your eyes peeled for those words, stay of imposition. And I will try and highlight this for you on when you're looking at cases that, this is an original felony conviction. You can have stays of imposition with misdemeanors that get dismissed, things like that. And again, I will do that analysis for you, but it's just something to be aware of. So inherent authority, it's those felonies that don't qualify for statutory expungement. There's no waiting period here. So once the case is dismissed, once the case is closed, not dismissed, you can file to expunge a petition. You can file an expungement petition. So I would not recommend, I don't recommend to clients doing it right away, because these are going to be the more serious felonies, and usually you'll need a long waiting period, even though it's not in the statute, to get a judge to agree to it. There are other things to consider other than just, does the case qualify by law? And also, I will do the screening for you, but just things to be aware of and to think about. All of the client's criminal cases should be closed. Petty misdemeanors are not crimes, they're citations. So having open petty misdemeanors, that you can do that. And a lot of clients have, especially traffic cases, sometimes they'll have tons of open traffic cases. And this is where we get back into that systemic racism issue, which is who's being pulled over, right? And so sometimes you have clients you can really see they have a long criminal history, long traffic histories. But if those cases are misdemeanors, they need to be closed. And that is something where I will help clients close out misdemeanor traffic cases that could potentially reset their waiting period. I'll help clients close those in a way that it's either dismissed or convicted as a petty misdemeanor. So they don't reset that crime-free waiting period with a traffic conviction. So I've already done that analysis for you, but you may see petty misdemeanors on your client's case that are open or unpaid, and that is okay. Fees and fines can be an issue. Judges will not approve criminal expungement petitions where there is a fine owed on the case itself. So that's something I'm looking at and should catch. Usually we don't see it being an issue if the client owes money through fees and fines for traffic tickets or other, it would be petty misdemeanor traffic tickets. Sometimes a judge will deny clients an expungement petition because they have open traffic tickets. I personally don't think it's fair to require clients to pay off all of their petty misdemeanors when they can't get a job because of their criminal expungement, their criminal history. So that's just a calculation that I've made, and we rarely see denials because of traffic tickets owed, but it is something that could happen, and that's just a balancing decision that I've made. So just something to be aware of. Judges also look at, they have a balancing test they look at, and it's basically, is the petitioner burdened by the record and are they rehabilitated? And they're weighing this against the public's right to know about the record. We'll get more into how you prove these things. There are 2 essays in the petition that cover both of the burden and the petitioner's rehabilitation. And then the burden does vary based on which statute you qualify for expungement for. So even with dismissed cases that are fully resolved in the client's favor, it's not automatic. The client still needs to show the judge, at least some evidence of, burden and rehabilitation. All right, how do you take a case through Volunteer Lawyers Network? So the first thing you're gonna do is sign up with as a volunteer with VLN. Just kind of a general estimate, it usually takes our volunteers about 10 to 15 hours for one case, spread over 6 to 8 months. I've estimated that it's about 3 additional hours per case, and that's because a lot of the information is usually the same. There may be some case details that are different, but most of the information will be the same. And we also have that program that will create the documents for you called Hot Docs. So it's not too much extra work, but of course it is case and client dependent, and most of the extra work is going to be administrative. So volunteers usually cover costs. Those costs can be mailing costs, or they are mailing costs, and then potentially getting records. So usually people's firms or they themselves cover it. If you are not willing to cover it, that is something you should put in the representation agreement, write that in and discuss it with your client. The clients do need to pay the filing fees if their fee waiver is denied. all of our clients, you can file a fee waiver. Some of them it gets denied. So that's also something to discuss with the client up front. But usually they get that fee waiver, and that's not a problem. As far as how much the cost could be to you, it involves printing. One case involves printing 10 petitions and mailing them to the court, 10 to 12 petitions and mailing them to different agencies, and then one to the court. I'm sorry, it's just service. So it'd be mailing them out to 10 different agencies, 10 to 12 different agencies. And if the client has multiple records, it can get be $30, $40. Sometimes it can be more than that, depending on how many records the client has. And then complaints, I believe they're about $9 each. So, if you are concerned about cost, please let me know. And I can discuss some ways to get around that, or I can try and find documents for you, things like that. When you're meeting with the client, most clients are comfortable with Zoom or talking on the phone. You can do the whole process remotely if you would like to. At this point, I can't guarantee that hearings will be remote, although we're seeing almost all of them still are remote. But just something to be aware of. To take a case, we send out monthly case placement emails. So, I'll highlight some things on those emails, like good for beginners, good to try a prosecutor-led expungement, great need, things like that. If you want us to advise you on what case is appropriate for you, let us know, and we can help you with that process of picking a case. Once you pick one, we'll send out a conflict check information to you. And if everything is good to go, we'll then email you the client contact information, their records, what cases qualify for expungement and why, under what statute or type of expungement, and any details that we haven't shared in the case placement email. If a case qualifies for statutory expungement, you can choose if you would like to do a prosecutor-led expungement, PLE, or the court process. And that's, again, something that you can ask me about if you want to do a PLE. I have information about which counties, which prosecutors are interested in that. There are some counties that are really great on this, and some that I'll say, maybe not this case. We have a training on reading criminal records. I think it's most helpful to look at the training when you have the client's criminal records in front of you. So it's really helpful to understand what's going on, because criminal records can be confusing. And there's also a glossary in there to help you understand what words you're seeing, things like that. You'll complete a representation agreement with the client and then get started, interview your client, give them follow-up tasks to do. And it's always good to walk them through the timeline and explain next steps to them, just to remind them of the process and set expectations. The arrest letters process is very simple. The court website has templates. You're just filling in some basic information and mailing those out to a couple locations. So the PLE process it has some really big advantages over the court process. However, it's just a little bit more unknown because it's new, and the statute that lists the process is very simple. So there's no filing fee, there's no petition, there's no hearing, and there's no service depending on the county. So that's most of the work is eliminated on this one. The downsides are it's totally up to the prosecutor. The timelines are very different based on what county and what prosecutor you get. And so it's just a little bit, if you like certainty, this is not the route to go. However, there are these huge upsides to it. So if you'd like to do a PLE for your client, let me know, and I can tell you, hey, this is a great case, or no, try again on a different one. And it may be that some of your clients' records are really good, to try a PLE, and others you'll just want to start with the court process. One of the nice things is that you can just ask the prosecutor in the case, are you willing to do a PLE on this? And if they say no, you start the court process. So there's really no downside in trying to do the PLE route. And if, the prosecutor agrees to it, it's much less work. There's no court hearing. There's no chance the client may have to pay. And if there's no service, that's most of the administrative work right there. And in some counties, it can take 3 weeks, the whole process. Some counties, it takes longer than the court process. So again, this is why it's helpful if you want to do one, just email me and I can give you some tips on that specific county. So if you want to do a PLE, as I said, you contact the prosecutor in the case, see if they'll agree to it. If they do, you're going to prepare the stipulation and the proposed order, and then get it signed by the prosecutor. You're going to want to clarify with the prosecutor and the county court if you have to serve them. For some counties, we know, for example, Hennepin and Ramsey, you absolutely have to serve them, just like in the court process. You also want to make sure the prosecutor is agreeing to expunge all of the records from the agencies that you need. So for if you have to serve the case for that county, it'll be the same agency as during the court process. No matter what, even if the county doesn't require that you serve it, you will have to still serve the Department of Human Services and the Minnesota Department of Health if you want them to be bound by that order. So under the criminal expungement statute, you have to serve these two agencies in order for them to be forced to expunge your client's records. So this is going to be really important if your client has a healthcare job, has been denied a job by either of these agencies in the past. So this will be anytime your client wants to work or has worked in the past with vulnerable adults, like nursing, personal care assistant, treatment, drug counselor, things like that. You'll then e-file the stipulation, the proposed order, and the proof of service if it's required, and the certificate of representation. And then you just wait for the judge to issue an order. Again, it could be a few days, and the judge could take that full 3-month period that the statute gives them. All right, now let's get into the court process. The court process is for inherent authority cases, juvenile cases, and all the cases that fall under that 609A statutory statute, the main expungement statute. We have a hot docs, which is a generating tool. So you just put all the information in once, and then it will generate all of your petitions for you in a Word document. You can use the court forms. They're on the court website. And if you don't want to start a hot docs account, that's also an option. When you complete the petition, use the first person. Err on the side of including things with explanations. A couple of the issues we see where judges deny cases will say you excluded or left out information. The client isn't being forthright. They are potentially lying or trying to hide things, or they aren't taking responsibility for what happened. So always erring on the side of inclusion and explanation is important. And then also having the client take responsibility for what happened with cases where they pled guilty or where there's a conviction. And then also making sure the client isn't relitigating what happened in the case. So, we do have some clients who will say, oh, I'm innocent, I was railroaded, this isn't what happened. I have screened for clients who are absolutely not willing to take responsibility in court because those are people who are not going to be successful. But most of our clients, they understand it. It may just take a conversation. So those are the big pitfalls right there. When you can verify information, by using court records or police reports, and don't rely on the client's memory, which may just be old and maybe, have a different interpretation of what happened. As I said, clients remember things differently, or they are unhappy with the outcome or things like that. So sometimes what they tell you is different than what's reflected on the police report. Most of the petition is administrative. So you can, there are 2 essays that you really prove your case on. Essay number 5, which is the burden statement, and essay number 13, the rehabilitation statement. The essays can be, 2 to 3 paragraphs, which is ideal. Sometimes, I know people have a little shorter, a little longer, but we do have some examples of what that looks like on our website, which I'll go over with you so you can see an example petition and where to find all those, some of the resources I'll be talking about today. The other thing is, because this petition is so administrative, if you have a paralegal or an assistant or some other non-attorney in your office who you would like to help you with this, they can prepare the full petition as long as you are checking over things and approving it, as the attorney. They can do that. So they can be very helpful in this process. So I'm not going to go through every single question on the petition because some of it is straightforward. So I'm just going to hit the important points. Number 5 is the burden essay. This is proving to the court why the client needs an expungement. How is the client, where are these records coming up in the client's life that's hurting them? So usually this is going to be jobs, housing, or volunteering, getting involved with a child's school, things like that. It's important to go into details. One of the pitfalls we see is a judge says, they haven't provided detailed evidence, that this is hurting them. So, just if the client can remember specific jobs they've been denied from, if they have, and then if they have evidence. So, those specific places they've been denied, specific instances they've been denied, and then supporting evidence would look like job denials, housing denials, a lot of denials usually. And you can get creative with that. Wherever the client is saying, this is a problem to me, talk about it. Number 6 is going to be the petitioner's criminal history. Petty misdemeanors are not crimes. So you don't need to list petty misdemeanor convictions here. You will want to list all misdemeanors, gross misdemeanors, and felony charges, even if they were dismissed and above. The list is here. It also involves out-of-state crimes. So you're going to want to list all of that here. Number 7, some people like to list the petty misdemeanors, especially if the client has an extensive kind of driving history or some same or similar petty misdemeanors as number 6, for example. There are some, petty misdemeanor thefts. You can disclose that in number 7, but you also, it's kind of optional. In number 8, you're disclosing current or concurrent and prior expungement requests. Number 9 is where you're telling the court why this case qualifies for expungement under the law or inherent authority. So starting at the top, this first box is going to be the controlled substance cases that have been dismissed. The next one is cases certified or for adult prosecution, juveniles certified as adults. This is not the juvenile statute. That is a different statute, and Hot Docs will pick that out for you. So you, but just know that just something to pay attention to. The next one is resolved in favor cases. This is going to be where there's a dismissal or acquittal with no guilty plea. The one after that is going to be dismissals with a guilty plea. So this is going to be usually going to be your stave adjudications or divergent programs. After that, you have petty misdemeanors or misdemeanor convictions. Then it's gross misdemeanor convictions. And finally, you have felonies that qualify for statutory expungement under 609A. After that, you have inherent authority records. So that's why you can use the same form for basically everything for the court process, but those juvenile cases. All right, then we get to victims. This is another chance for the client to show a judge that they are taking responsibility for what happened here by disclosing the name of a victim. Sometimes there aren't victims, and that's okay too. If there is an order for protection, you need to list that also. Those protective orders are going to be DANCOs, which are domestic abuse no contact orders, OFPs, which are orders for protection, and then restraining orders, restraining harassment orders, HROs. And you do need to attach those to the petition. All right, number 13 is the other essay. So this is where the client gets to brag about all the good things they've done since they, got into trouble. So, and you're proving to the judge why the client is not going to be a threat to public safety. They're not going to reoffend, and they are rehabilitated. And you should fill out this statement no matter what. If the client has a dismissed case where they've not admitted guilt, you still want to show positive things about the client. They don't need to take responsibility for what happened, but it's still important to show a judge this person deserves to have this case expunged because it's not automatic. When the client has been convicted, that responsibility piece is very important. So what I like to do is just have a couple of sentences about what happened in the case, making sure not to relitigate or argue with the outcome of what happened, not making excuses here. No relitigating the case, as we say. Then have the client take responsibility for what happened, especially for those convictions. And then you can focus on rehabilitation. This should be the bulk of the essay. In tying, it's important also to tie the rehabilitation to the crime. So, if it's a domestic abuse, a conviction, did they have to take anger management classes? Did they have to take, did they have to go to Tubman and take a class on domestic abuse, violence, and what that is? Are they doing therapy? Have they had to take parenting classes? And so you can kind of, go through, with a drug addiction or alcoholism, are they drinking anymore? Have they gone through treatment? Do they have, a sponsor or graduation tokens that they've got? And then, all the good things, basically just throw everything at the board, all the good things the client has done to show a judge that they deserve this expungement. So volunteering, things in the community, church, anything positive about involvement with family, anything that shows, hey, I've changed and, here's why. You're going to check both boxes 14 and 15. 14, make sure that any agencies who you've served, who object, who have confidential data are going to keep that confidential and not reveal it on the public record by filing it in the case so that more harmful information doesn't come out about the client. Number 15 means that if the expungement is approved, that the agencies, when that gets served, when they seal the record, they have to send in a letter confirming that they did it. We just say don't do number 16. It can get into excuse territory. So you can address kind of these mitigating factors in number 13. For example, if the client was a victim of a domestic abuse, and this came out of a domestic dispute, you can address that in number 13. Number 16, it just is one of those kind of pitfalls we find where you really don't want to have the client seem like they're making excuses for what happened. And so that's why we include that in number 13, where it can be more of a holistic answer. So here you can just put C discussion in number 13. Then you'll get to the fee waiver. Court fees are about $325 per case. So when clients have more than one case, it can get very expensive. All of our clients have been screened for eligibility. As I explained previously, they're all at least 200% of the federal poverty guidelines and below. And all of our clients have come to VLN because of indigency. And so they should all qualify for a fee waiver. The client's income may have changed since we screened them. So please just do a screening again when you're filling out the fee waiver form. People qualify for IFPs because they are represented by a pro bono attorney. So again, they should qualify for this. However, the court's line is 125% of the federal poverty guidelines. So it's okay if the client's income is above that, because again, they should still qualify. But some judges, they may see a client with a higher income and say, well, you have to pay a partial fee, or I'm still going to deny this. It does happen sometimes. So, just being aware that 325 fee can be quite steep for some clients. You need a fee waiver with every case but dismissed cases. And those are those resolved in favor dismissed cases. So it's only when a client hasn't admitted any guilt on the record that they do not need to file a fee waiver. Hot Docs does this for you. So, just something else to be aware of. There are two little things to notice with fee waivers. We do have a short IFP. Some attorneys hate filling out IFPs. So if you just want to have the client sign an affidavit saying, this client is represented by a pro bono attorney based on indigency, they qualify for a fee waiver. We do have that, and then you don't have to go through the financial screening at all. Hennepin and Ramsey have accepted it in our housing programs. So, we're hopeful that will work with criminal expungement as well. Other counties, we don't know. So that's what that short IFP is on our website. The IFP table is for clients whose income is over 200% of the federal poverty guidelines. And this is to show judges, even though this client's income looks high, you should still grant the fee waiver. And that's because we have this little chart where you can list the client's expenses and their income to show the judge, this client really does not have the funds to pay for, $1,000 in fee waivers or whatever it is that the client would owe. You're gonna review, generate, once you're done with the petitions, you're gonna generate the Word version through Hot Docs. You're gonna wanna review it for accuracy and edit it. You only would need to craft a proposed order in an inherent authority case. And that's because that order is so important, because it's something that the client is going to give to employers and landlords and volunteer opportunities to say, hey, I know that I have this on my background check, but here's an order from a judge expunging it, talking about all these good things I've done. It's very rare you would have to write any memorandum of law or have really any other document than what Hot Docs would generate for you. The client is going to then need to sign the petition and fee waiver, and then you're going to schedule a court hearing. You're going to do that. To do that, in most cases, you'll call the county, just call the county court administration up and set that date. And it needs to be 63 days out by statute. Usually, I would just recommend building in like 10 to 15 more days, because just making sure you're giving yourself time to complete service and filing. Once you have a court date, enter it at the date, time, and location in the notice of hearing section of the petition. then you're going to finalize that service of process form. So as I discussed previously, service is mailing the petition out to agencies that were involved in the initial court case. So it's up to about 12 agencies. The first thing you're going to want to do is verify the addresses. Hot Docs will generate these addresses for you, but you'll need to double check them, especially the smaller counties and cities, because the addresses can be outdated. So you're always going to serve boxes 1 through 8. The service of process form, it comes out in a grid. So it has numbered grid boxes, and that's what these numbers refer to. So you're always going to serve boxes 1 through 8. Boxes 9 and 10 are the Department of Human Services and Minnesota Department of Health. You're going to need to serve these when the client has been disqualified by these agencies in the past for work with vulnerable populations. So nursing, PCA, addiction, counselor. Usually the clients will know, like, oh, I've had problems in the past. Sometimes they don't. It's better to serve these agencies than to not, because otherwise they won't be bound by the order, and the client will continue to have problems finding work in what are often very good jobs for, associate's degrees or, entry-level jobs. Boxes 11 and 12 are very rare. The DNR is for like hunting infractions and licensing infractions. So I've honestly never seen that one served before. Department of Public Safety is for traffic cases. And usually the record will say like sent to DPS. We don't do that many traffic cases. So it's rare that you'd have to serve them. But if you think DPS it may have this record on file, you can serve them. All right, then you're going to mail the petition, including evidence and the proposed order, to every single address on the proof of service form. The person who does that will complete and sign the proof of service, and that you're going to include in the original petition, and you're not going to serve that. Then you're going to file the case. Because you're fully representing a client, you'll have to e-file the case. You have very detailed instructions on how to set up an e-filing account with the courts and how to e-file if you've never done that before. Just some tips here. You're going to want to go to the original criminal case and add yourself as an attorney. So with criminal expungements, you have that court file number, and basically what you're doing is filing back into the original criminal petition and expunging it that way. Something I should mention at the beginning of this presentation is that with a court file number, there can be multiple charges under a single number. Expunging a single criminal petition with that court file number will expunge all of those charges. So you just need to do it one expungement petition per court file number and not for each charge. So you'll go to that court file number and add yourself as the attorney. Make sure to add yourself as a service contact, because that's how you're going to know if new documents are filed into the case, either by an objecting agency or by the court itself. And then you're going to use the fee waiver account. This means you don't have to put in your financial information. Finally, you're going to want to mark the IFP, so that fee waiver, and any other documents that are confidential as confidential when you're e-filing it. And this stuff is all on those e-filing instructions, but these are just some things I wanted to highlight. So usually this is going to be the petition. The only other document would be like a petition with expungement, with exhibits that have therapy, medical records, things like that, that could be potentially confidential. So you'll just want to mark both the IFP and then any petitions that have confidential information in it or attached to it as confidential, so the court knows, and they will, they won't put the IFP online, and they will put the petition online, but then they'll know to keep any confidential exhibits separate. You're going to e-file the petition and exhibits, proposed order, certificate of representation, proof of service, and then, if appropriate, the IFP and IFP or proposed order. So these hearings are pretty short. They're 5 to 15 minutes. Just a reminder, I know some of our volunteers are not used to, litigation or court hearings or things like that. This is a process, and the hearings are meant for pro se parties. So you do not need to know the rules of evidence. Really, you are just using your skills as someone who is familiar with the law and more familiar with the legal system than your clients, using your practical, wisdom and helping your client tell the best narrative they can to the court. And you can use that petition as the basis for preparing for your court hearings. They are very, very, very likely going to be a Zoom hearing. There's a county or two, likely Anoka County, that are going back to in-person, but very likely it'll be on Zoom. You may get an objection. So any of the agencies you served can object. The objections can be e-filed, so in advance. Sometimes the agencies will send someone to appear in person, and they can actually question your client. But usually what they do is they just, e-file something and don't show up. To respond, you can e-file your own response, or you can respond at the hearing. Prepare your client by discussing, basic courtroom etiquette, making sure they can get on Zoom, practicing that with them, preparing the client, helping them respond to questions. You don't know if the judge is necessarily going to talk to you or your client. Some judges, it usually just depends on the judge. They may do both. So making sure that they are ready to answer some questions just based on the petition. So rehabilitation, burden, and maybe what happened. Some judges like to know what happened. The best thing to do is try and observe a hearing with the judge assigned to your case, if you know, or just in that county. And you can do that by calling up the county court and figuring out a calendar that you can observe via Zoom. You're going to want to prepare opening statements and an outline of the client's case. Again, based on that petition, and then also addressing any arguments related to objection letters. All right. Once you get the order, whether approved or denied, explain it to the client. If it's denied because of timing, usually we recommend 2 years before they reapply. There may be other things that the judge says they need to do, and you can talk about those with the client too. If it's approved, there's that 60-day appeal period, after which the court will expunge the records and tell all the agencies to expunge records as well. After that, background check companies update their records. They update them every couple of weeks, so the client should shortly be able to apply without the record showing up when they're applying to jobs and housing and things like that. The client needs to keep copies of the expungement petition because the expungement order, because sometimes the background check companies miss a record and it may still show up, and they'll need that expungement order to challenge the background check company. Finally, you'll close the case. You're going to write a letter to the client ending the attorney-client relationship, and then you will fill out VLN's closing form and send us the orders, and if you haven't already, the representation agreement. So we always have a wait list of clients for full representation. As I said previously, we send out an email at the beginning of each month with new cases. Generally, those cases with 1, 2, 3 go pretty fast. We do have clients who wait months, who have more than that. And just because a client has multiple case records doesn't necessarily mean it's a more difficult case. Someone can have a single case and it can be more difficult than someone with numerous cases that are, lower level or very old, things like that. I also think with people who have multiple cases, if you have a paralegal or, assistant or someone who can help you with some of that administrative work, it's the actual writing of petitions isn't going to take too much longer. It's more the administrative work. As I said previously, if you have, someone who can help you who wants to, watch this presentation and be trained in this, we have paired attorneys and paralegals before, and it works really well, especially for those clients who have a few more cases who you may not want to take on by yourself. But those are the people who are really waiting a long time, and would really encourage you to just take a look at those. Especially if you've taken a case before, taking on someone with a few more cases is really appreciated. And also trying out prosecutor-led expungements. This can really lighten the load a little bit when there's, someone with numerous cases. If you can get a few of them done as prosecutor-led expungements, and then do the court process for others, that can help, make the process a little bit shorter, or do less paperwork also. Just gotta push you in that direction as a program manager. I'm happy to offer you any support you need one-on-one. Any questions you have, you can just email me. We do a Zoom training at the end of each month. So if you need a refresher or want to ask questions, you are welcome to join those. And then this website right here is the criminal expungement website, and I will walk us through that in a second. What resources we have there? We're always adding new things and thinking about how we can make this process easier for you as volunteers. So if you have any suggestions or looking for something, let me know. There is a representation guide coming shortly, which goes into each of these steps much more deeply. So you can look for that on the website, and just use this presentation as an overview of the process. All right, finally, here is contact information, which you should have already, but so as I said, I'm Liza. I'm the program manager and attorney on this, and Barb is the case placement coordinator. If you have a question, generally, you can orient document questions like sending and like, how do I communicate with the client's not responding, things like that can go to Barb. And legal questions, you can orient to me, one-on-one help, other things like that. But really, either of us you can contact. All right, now I'm going to switch over to our website. So when you go to VLN's website, you find the criminal expungement page by going to volunteer. And then over on the side under in the little blue box, you go to criminal expungement volunteer resources. So on our website, under criminal expungement trainings, we have this PowerPoint, and then this recording will be listed on here as well. The full representation guide will be coming soon, as I said. This chart of criminal expungement statutes, waiting periods, and burden is very helpful to look at all of the statutes next to each other and compare them. And it's just helpful to see it out in chart form. And then it also has the burden and waiting period on there as well. There's an example petition with example essays in it. The e-filing guides, how to set up an e-filing account with the court, and then how to e-file. And then we have criminal records resources. So when you are, working, looking at those criminal records, you get them and you're like, what do I do with these? Where do I find, where are all the sources? This training on criminal records can be very helpful. It's a PowerPoint, and it just walks you through what to look for, and then has examples of things to look for as well. There's a sample court record and sample Bureau of Criminal Apprehension record as well, which are things that we send you and which you'll need to look at. And then we have some helpful documents for your case. The VLN representation agreement, the stipulation and proposed order for the prosecutor-led expungement, the templates are there. We have the short IFP affidavit and then the expense table. Then we have some additional educational resources. We have the VLN handbook, which just gives a great overview of any question you may have as far as, how do I interview a client? What are, how do I handle certain issues with cases, things like that. We have a recording on the collateral consequences of criminal convictions, looking at racial disparities in the criminal justice system, things like that, which are really important part of criminal expungements. A general article about race in pro bono services. Some more information on working with indigent clients. And then working with gender diverse clients, if you have a client who is trans or has specific pronouns they want you to refer to them as. And then also a resource on trauma-informed lawyering, both to understand your client's reactions. So this might be very helpful if you have a client who does have an outsized reaction or is shutting down to things, or has domestic violence, been a victim of domestic violence, things like that. Just a general understanding of how trauma impacts clients and how that can impact your relationship, but then also how trauma can impact you as an attorney. Some of our clients and the things they've been through are very intense. They may have done very intense things and committed serious crimes, and learning about that and working in pro bono services you can get secondhand trauma. So learning about that I think is really important, and make sure that you don't burn out or become jaded, things like that. So if you have a suggestion about other things to add to our website, please let me know. This is kind of a new resource, so we're updating it and improving it, all the time. So thank you so much for your interest in volunteering with us. We do hear from clients that this process changes their life because they are able to get jobs, get housing, support their families, and remove the stigma of a criminal record from their background check. So, thank you so much. If you need any help, please let Barb or I know, and please take a case. So thank you.